is your viewpoint on the Constitution, and how will this affect you in deciding cases of extreme crimes?
I believe the Constitution as it's originally intended. I don't consider my opinions and my political agenda into the words of the Constitution. I view the Constitution as it was originally intended. In cases like Fox v. Jackson, the judges were tasked with examining the meaning of the 14th Amendment, not to infer that the framers of the Constitution wanted the words abortion added in the text when they wrote the Equal Protection Clause. That's how I decide my cases.
How will the Constitution evolve then?
Well, it will evolve through the ballot box. I'm not in favor of legislating on the bench. I think if the people want change, they have to do it through the ballot box, through amendments, not through judicial review.
James Madison argued that the Bonus Bill of 1817 was unconstitutional and vetoed it. The bill, the construction of roadways, if it was brought in front of Supreme Court to deem whether it was unconstitutional or not, originalists dominated Supreme Court would deem Madison correct. Does that suggest that all the roads would have to be torn up because it was deemed unconstitutional?
Obviously not. Any serious judge would never undo previous case of serious importance. It would be irresponsible to overrule every previous case, even if it was wrongly decided.
Okay. So what about stare decisis?
From Judge Barrett's words, there's the belief in a soft ruling. Judicial review is not law of the land, and it's not absolute. It can still be overturned. The court should follow stare decisis in most cases because it can show legitimacy and consistency in the court. However, there are some cases that should be overturned.
So were you in favor of Dobbs v. Jackson?
Yes, I was. I think that the Roe v. Wade bench had got it wrong. I think that they inserted too much of the political agenda into the case. I think benches like that have too much power, and we live in a constitutional democracy. One, the framers of the Constitution, they added checks and balances to ensure no other branch wield more power than the other. So when a bench full of living constitutionalists rise, the legislative branch receives too little power.
When y'all get through, chairs come back in here. You're not supposed to be moving the chairs.
Okay.
And the judicial branch too much. Living constitutionalists can legislate while on the bench, and this can hurt our democracy immensely.
How does it hurt our democracy?
So I love how the way Justice Scalia said it, who's passed now, but he explains it as it killing the Constitution. The Constitution works by way of people's vote when a judge tries to implement his views and political agenda into that. It takes away the power from the people. Judges who are not elected by the people cannot make extreme decisions like that. Likewise, when judges implement their views in the Constitution like that, it takes away the absolutes, and that puts people's rights in jeopardy.
Absolutes?
Absolute laws are things that cannot be changed or modified because they're essential for the basic rights of democracy. Absolutes can be seen as the First, Second, Third, Fourth Amendment, things like that.
What did the founding fathers think of originalism?
So there are some different opinions on it. Hamilton saw it as a living document when he tried to implement his national bank. However, Washington saw it differently. In Washington's farewell address, he addresses the issue and discusses how quick fixes in the government are not the right way. That patience and trust in the government to fix the problems with the right way to work out the mistakes.
Do you agree with Washington?
Yes, as an originalist I do. I believe that when judges use their political agenda, their radical viewpoints, it damages our society. should always go through Congress. Legislating on the bench is not right. It can be slow. I understand amendments are slow. It's a very, and it's an extremely hard process.
A tedious process?
Yes, but it takes patience. When that patience comes, the outcome is great. It leads to a stronger society that embellishes the principles of being American. It leads to a stronger society of people who grow stronger socially, economically, and politically through this patient process.
Okay, thank you very much. The ruling of New York State Rifle and Pistol Association versus Bruin was recently decided. It displayed that gun restriction on people who didn't need the protection was unconstitutional and had a major outcry in the nation, with some defending the decision and some attacking it. Why is this a big win for not just Republicans but also originalists?
Well, yeah, I mean, it shows that some gun limitations are not being tolerated. And this is obviously one of them. This 100-year law shouldn't have stayed there that long. It was clearly unconstitutional. The concurring opinion from Justice Kavanaugh explains how the Second Amendment is vague. However, it describes how the words shall not be infringed, how this law can clearly violate that. New York was deciding who gets guns and who doesn't, pretty much. And this is not protection of the Second Amendment. This is why he violated it. And so I agree with the judge's opinions.
All right, thank you. Final question. Some argue that the vague parts of the Constitution, such as equal protection, cruel and unusual, and unreasonable, cannot be interpreted as well as a different point of view, and that since this Constitution is not going to have the opportunity to grow, what do you have to say about this?
Well, I think that is a good argument. So, I mean, words like that are extremely vague. And if you look at what being an originalist means, it's going to be hard to interpret that. But I would like to look back at history. Look back at the historical significance of the words and try to put myself in the point of view of the framers as much as I can. And sometimes as originalists, we do have to insert our own opinions into the words. We can't just be textualists. However, what separates us from the living constitutionalists is we're careful with every word, every meaning, every opinion that we have to insert into our viewpoints and through the Constitution. In cases like Roe v. Wade, the bench got it wrong. They just inserted too much of their
Personal agenda?
Yes, exactly. And when the Constitution grants equal protection, the framers never intended for abortion to be part of that. But if you look at other cases like Miranda v. Arizona, this case made it so officers had to read criminals their rights, and it was decided in the Fifth and Sixth Amendment. If self-incrimination and the right for an attorney. Now, the judges were tasked with an extremely hard decision to interpret words that were extremely vague, except I think they did it great. They added in what was necessary to advance the Constitution in our society, but not too much. Not enough to hurt our democracy. They did it just enough so they can evolve the Constitution and bring it forward, but not divide our country. This is how I think originalists should be. Not to insert opinions or be too radical, such as the latter case.
Okay.
Any other questions that you wanted to make?
No, I think